What's up, guys? Brian Fel Law Group PLLC here with your Florida Law Weekly Case Update. Got 3 cases for you. It's a beautiful day and it's Friday, so let's get right to it. Let's get into the cases. First case I thought was very, very interesting. It has to do with comedy, and not like ha 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 comedy, but COMIT. Has to do with when can you defer to a foreign court, foreign jurisdiction. So the parties here in this case, it's Carrasco versus Jimenez. It's out of the 4th DCA. Apparently, the husband got a final judgment of divorce in Venezuela while the wife was filing for divorce here in Florida. And so, my general understanding of comedy, and it's actually in the statute, in the Florida statutes, it's, I believe it's 61.0401, and it says, a judgment or order of a court of a foreign country is not entitled to comedy if the parties were not given adequate notice and opportunity to be heard, the foreign court did not have jurisdiction, or the judgment or order of the foreign court offends the public policy of the state. So it's basically 3 different reasons, one of which is the foreign court did not have jurisdiction. So that's the real crux of the case here. Now, what I'm interested in is the 4th DCA ruled that the Venezuelan court did not have personal jurisdiction, did not have jurisdiction over the case. But the Venezuelan court found that it did have jurisdiction. So my question is, are we applying Florida law to see if Venezuela had jurisdiction? So we're saying, did Venezuela or did the foreign country have jurisdiction under Florida law? So if that's the case, that could be a much higher, different standard than, let's say if people properly get divorced in their own foreign country, in their own home country, and let's say in that country, service of process can be by certified mail or something like that. Well, that technically wouldn't count here in Florida. So would that mean that their divorce decree in the foreign country is invalid because the court technically lacked personal jurisdiction over them because they didn't, issue service of process properly, or maybe in the foreign country you can have personal jurisdiction if you were married there or you had a home there or something like that. So really it's a question of which country's laws are we applying. So interesting. Well, here they said the court in Venezuela, well, you're wrong. You didn't have personal jurisdiction under Florida law. You didn't have subject matter jurisdiction either because the parties didn't reside in Venezuela for the last 6 months. So interesting case to me. Basically, you really got to show jurisdiction pursuant to the laws of Florida, whether the foreign court had jurisdiction pursuant to the laws of Florida. Interesting case for me, especially here in South Florida because we have a lot of these foreign cases. Next case is BD versus Department of Children and Families. So this is a great reminder. This actually, not this exact same thing, but something similar happened to me this week where you're at a hearing and the judge maybe goes a little too far and starts making comments that end up getting the judge in trouble, so to speak, where the judge has to recuse herself. And so in this case, the judge did not recuse herself or himself, but basically the judge held an in-camera hearing or an in-camera interview with the child. And after the interview, of course, the parent who was complaining was not present. And so after the interview with the child was conducted, the guardian ad litem was there, and then the lawyer for, I believe, the Department of Children and Families, I believe that lawyer was there as well. The guardian ad litem and a case manager. So it was the guardian ad litem, the court, the judge, and a case manager. They subsequently started discussing the case after that interview with the child. And that was too much. The court was allowed to interview the child, yes. But once the court starts talking substantive issues with the guardian or with the case manager or something like that, that's when it becomes a little too far and the parent has a right to be present. Otherwise, those are ex-parte communications. So this judge denied the parent's motion to disqualify, and the appellate court reversed and issued a writ of prohibition. So got to be super careful in those situations. If your judge is sort of going a little too far, maybe just try to rein them in and say, Judge, I don't want you to get disqualified. Let's kind of narrow it down here and watch what we're saying. Last case is as Cirillo versus Cirillo's second DCA. Just a great reminder that, guys, you got to have reservation for a charging lien if you want to get an attorney's charging lien in your case. In this one, final judgment did not reserve for a charging lien, so the appellate court said you're not allowed to get to enforce your charging lien if the final judgment does not specifically reserve jurisdiction to award and adjudicate the charging lien. All you need to do to perfect the charging lien is provide adequate notice. Just file a notice of charging lien in your case before the final judgment is entered. But make sure that final judgment specifically says the court reserves jurisdiction to adjudicate the charging lien. If not, you won't have jurisdiction to adjudicate your charging lien. So please do so. All right, guys. Well, I hope you enjoyed it. Hope everybody has a great weekend. We'll see you next time. Bye.